Yes, Mr. Ward.
Good morning, my lords. Together with my learned friend, Ms. Charlotte McGibbon, I represent the appellant in this matter, Mr. Campbell. My learned friend, Mr. Joshua Swirsky, appears for the respondent local authority in its capacity as the authority responsible for meeting needs under the Care Act 2014. Of course, in this case, it is also the local housing authority insofar as that's relevant. My lords, firstly, just by way of housekeeping, uncontroversially, you should have a core bundle, supplementary bundle, bundle of authorities and replacement skeletons from each of us. Perhaps slightly more controversially, a supplementary note from my side submitted yesterday. I understand from my learned friend, Mr. Swirsky, that he doesn't object, but of course it's a matter for which I...
Well, I don't know how much further it takes us, but Mr. Swirsky was able to respond within about 3 hours of being notified, and in those circumstances we wouldn't put any obstacles in your way.
I'm very grateful, my lords, and I can only apologise profusely for its lateness, which I take personally full responsibility. It was simply that when I was preparing my submissions, it occurred to me that legislative history may be something your lordships were interested in, and if you were, it would be better, I judged, hopefully not misjudged, to have that available rather than have to compile it at short notice over a short adjournment. So I present it to your lordships just on that basis.
Yes.
My lords, my client, Mr. Campbell, is a British man who is therefore eligible for assistance under the Housing Act 1996, and who also has what are termed eligible needs under the Care Act 2014. It is a feature of this case that one needs to be a bit careful with terminology, because eligible does not mean the same thing under the Housing Act and under the Care Act. Mr. Campbell was accommodated by the respondent for several years, purportedly, and it can only really have been in exercise of its duties under the Care Act 2014, but it is now said by the respondent, and was found by the learned judge below, that the respondent had no power to provide that accommodation under the Care Act, because Section 23 of that Act excludes provision of anything that an authority is required to do under the Housing Act 1996. So the short point really is within relatively narrow compass that arises on this appeal is whether Section 23 of the 2014 Act means that the fact that a person is not ineligible for assistance under the 1996 Act, and effectively that's because, like Mr. Campbell, they are not a person subject to immigration control, does that mean that they cannot be provided with accommodation under the Care Act 2014, at least if it's a type of accommodation that might potentially be available under the Housing Act? Or to put it another way, what does something that an authority is required to do under the Housing Act 1996 mean in Section 23? Now, I put it that way because that's the basis on which this case has been defended by the respondent, and the basis on which the decision below was reached. Unusually, it's not an issue that emerges from the decision under challenge, which you have at the back of your core bundle at tab 15, but to which I'll be making relatively limited reference, at least in relation to this issue of principle, because it's a legal argument raised by the local authority, one line in the very last pre-action protocol response, but developed in its summary grounds of response. So in terms of ground one at least, the focus is very much on this as an issue of principle. My lords, I propose in submissions largely to follow our skeleton argument, so to deal firstly with the statutory framework under the Care Act and when accommodation may be provided under that Act. Secondly, to deal with the Housing Act and what duties that imposes on housing authorities. Thirdly, then, to to deal with the interplay between the two, and what Section 23 does. Fourthly, to sweep up on why then, I say in the light of those submissions, round one of the appeal succeeds. And finally, briefly, to deal with round two, which is a reasons, rationality, purpose challenge to the decision itself. My learned friend, Ms McGibbon, and I have considered whether a split of advocacy might be appropriate in this case. We weren't able really to devise a way of separating out sections within ground one, and the case on ground two is very fully set out in our skeleton argument. But it is the case that if your lordships have any detailed questions about the working out in practice of the Housing Act duties in real cases, then Ms McGibbon is almost certainly in a better situation than I might be to answer those.
Good.
So I put down that marker at the start.
Before you embark on this programme, Ms Ward, could you or Ms McGibbon please tell us what has happened in this case since the judge's judgment? Not because we're going to turn you away on the grounds that this is academic. We're here now, and nobody's suggesting we should do that. But we would like to know what happened when last recorded. Mr. Campbell had been allocated a tenancy. There was an argument about white goods. What has happened since then?
About the white goods?
Well, is he
he's
in the new property?
He is in that new property, yes.
Right.
And my lords, I think it's dealt with in both skeleton arguments. In fact, there was a reassessment. There was a visit to assess his needs in that new property. There is some factual dispute about precisely what took place there. I haven't anticipated
never mind
the need to trouble the lordships on that.
Since when has he been in that property?
The precise date is, it postdates the hearing below. October 23.
Thank you. Right.
Yes, so yes, it's paragraph 21 of our skeleton argument. The white goods hadn't been arranged when he signed the tenancy agreement, but they have now, and he moved in October.
Yes.
And conscious that my lord was not going to trouble me on the academic point, but just for completeness, it's dealt with then at paragraph 22 of the skeleton argument in terms of the arrears and the implications for future care planning. So, my lords, if I might then start with the Care Act itself. This is dealt with at paragraphs 23 to 30 of our skeleton argument, and the relevant sections are in tab 1 of the bundle of authorities. I take my lords to this legislation primarily to establish the group of people with whom the issues that arise in this appeal are concerned. I hope to take the structure hopefully quite quickly, because the purpose of the Care Act, one of the purposes of the Care Act, of course, was to consolidate and put in one place the various duties that were previously in the piecemeal scheme of legislation under the 1948 and other acts. And the first duty then on the local authority under the 2014 Act is the duty under Section 9, which appears on page 5 behind tab 1 in the bundle of authorities. The duty to assess whether an adult has needs for care and support, and if they do, what those needs are. And as will become apparent when, in due course, we look very briefly at the assessments in this case, Section 9.4, a needs assessment must include an assessment of the impact of the adult's needs for care and support on various matters that are specified in section 1.2, the outcomes that the adult wishes to achieve, and whether and to what extent the provision of care and support could contribute to the achievement of those outcomes. So that's duty to assess. Having carried out such an assessment, there is then a duty under section 13 which begins on page 9 of the authorities bundle. If, following that assessment, the local authority is satisfied that an adult has needs for care and support, it must determine whether any of those needs meet the eligibility criteria, which are dealt with in subsection 7 at the bottom of that page, which refers one out to regulations. Now, the regulations are not included in the materials before you. There is no dispute here that the appellant has eligible needs, and that's recorded in Judge O'Connor's judgment, paragraph 36. I don't ask you to turn up at this point, but for the court's record, it's at page 75 of the core bundle. There is no dispute that this appellant has eligible needs as identified under section 13. So then, having identified that there are needs and they are eligible needs, under section 18, which is on page 15, the local authority must meet those needs for care and support, so those that meet the eligibility criteria, if various conditions are met. See in subsection 1, if the adult is ordinarily resident in the area or present with no settled residence, that's not an issue here. Costs don't exceed the cap on care costs, and no charge or condition 1, 2 or 3 is met, and conditions 1, 2 or 3 relate to financial assessment, which of course my lords will likely have picked up from papers has not taken place in this case, because the needs that the local authority identified, my client already being in accommodation, were needs that he was satisfied could be met by support provided by his family. That doesn't stop them being eligible needs, and I don't understand there to be any dispute about that either. But the local authority has not accepted a duty under section 18 to meet any needs in this case. As I say, no financial assessment, but also it being the situation that, and you'll see at the bottom of the page there, 18.7, that the duties under subsections 1 and 5 do not apply to such of the adult's needs as are being met by a carer. So the needs in this case, which are needs for assistance with dressing, cooking, feeding himself, moving around his accommodation, keeping it tidy, have been, or the support that he requires there has been provided by his partner and members of his family. However, there remains an issue, and I'll come back to this in a moment, as to the circumstances in which that accommodation, or the provision of accommodation, can itself be a means of meeting needs under the Care Act. Before I show my lords the provision in relation to that, just over the page.
Sorry to interrupt. Can I just ask, if there is no financial assessment for the reasons that you're given, is there any obligation under 18 at all?
Well,
Because
this isn't, yes.
Seems to be a precondition under 18.1 A, B and C, and then picked up in 2, but that may be just a sort of misreading of it.
Well, my lord, the way the system works is the assessment has to take place, the needs are identified. There is then the process of care planning.
Yeah.
And if, as a result of that process of care planning, the needs that have been identified are going to be met by a carer, and the effect of what happens in this case is that the appellant doesn't want to have to pay for his needs to be met by his family members who are currently providing that service for free, so to speak. So the duty doesn't then crystallise to provide anything under Section 18 on the facts of this case. What happens instead, and I might say that happens because what the local authority has done under Section 19 over the page is to exercise its power under Section 19.3 to meet an adult's needs for care and support which appear to it to be urgent. That's the power that the local authority says it was exercising when it provided the accommodation initially in 2016, without having yet carried out a needs assessment or a financial assessment, or indeed made a determination under Section 13 in relation to accommodation needs. So it happens that way round. That doesn't mean that there is no duty that might crystallise under Section 18. It simply means the authority hasn't got as far as making that decision.
But for it to crystallise, there would have had to have been a financial assessment.
In the sense, yes, that we're talking historically now. The current position, as I understand it, I'm sure I'll be corrected from behind if I'm wrong, is that the appellant continues not to receive any package from the local authority because the care needs that he has continued to be met by family members. There remain eligible needs, and if at any stage his family were to cease providing those services, for example, then subject to completion of a financial assessment, the Section 18 duty would crystallise in relation to those.
Thank you.
But this isn't a case in which I say, which has ever been said, that the Section 18 duty has crystallised in relation to the provision of accommodation, because it's never been identified by the local authority as a need. And that may have been, could be a very interesting debate, but the basis on which this claim has been defended is that, well, it simply doesn't arise because Section 23 stops us providing accommodation at all.
I'm not suggesting that we should revisit the question of academic, because there does seem to be an issue of principle here which needs to be looked at. But one of your points in response to the academic argument was that there might be a historic claim for damages, but that won't arise, will it, if there should have been a financial assessment before any duty to provide care could arise, and there wasn't because the appellant wouldn't cooperate with it?
No, my lord, because this is a challenge to the decision to withdraw the accommodation and to cease funding it. And the challenge was brought on the basis that the local authority had not carried out a proper assessment to support that decision. And it's only then at that point that the local authority says, well, we weren't obliged to carry out any such assessment. We were never empowered to make the payments that were being made at all under Section 19 of the Care Act. Now, what was sought was a quashing of that decision, and that decision ultimately is the decision that led the local authority to stop making the payments for the period that it did.
Can I just then clarify? Sorry to just chase down this point, but if you were right that an assessed need in the particular circumstances of this case should have included accommodation, and Section 23 didn't mean what the judge said, then if the local authority had assessed that, in order to provide it, there would still have had to be a financial assessment before it was provided.
In order to provide it under Section 18.
Yeah.
But what the local authority did, and no one suggests this is by any stretch best practice on the part of the local authority, but it provided the accommodation under Section 19.3.
Under a discretionary power.
Which doesn't require, and so the focus then is on the decision to withdraw that and the reasons for the decision to withdraw that, and those are canvassed to some extent in ground 2, but the primary challenge to that decision was, well, if you had identified an urgent need for accommodation when you place the appellant in it. In order to make a lawful decision to withdraw that accommodation, you had to make an assessment that either identified that he had no such needs, or, and it is entirely possible, but also entirely speculative, that had the assessment been carried out, had a number of things could have flowed from that. Either that the authority determined that there wasn't in fact a looked after need, and I say for the reasons I'll come to, that's unlikely, or at least can't be said with any confidence. It could have made that determination, and then my client would have had his routes for challenging that decision. It could have determined that there was such a need, and that it was an eligible need, and therefore ought to be provided for under Section 18. And my client at that stage may nonetheless have not wished to provide a financial assessment, at which point there would have been no duty under Section 18. But that is speculation.
Thank you.
And
Sorry
he may
to
also,
take you out.
he may also, very well, understanding that this was the only way he was going to be able to stay in that accommodation, have then completed the financial assessment. But those are all hypotheticals, because what we're concerned with here is the decision to withdraw what was previously being provided under Section 19, not a hypothetical decision to provide or not provide under Section 18, because the local authority never reached that stage.
I suppose you're right. What would the measure of damages be?
It's not damages, my lord. It's the local authority had a decision in place to pay the accommodation provider.
Right.
Those payments ceased, and therefore that is currently a debt nominally from my client to the accommodation provider for the period when he remained in that accommodation but not being paid for.
Are they pursuing him for the debt?
Are they pursuing him for the debt? As I understand it, they simply stand as arrears on an account. He's not being pursued in the sense of action being taken, but it is an amount that he nominally owes the accommodation provider. But that if the local authority's decision to stop funding were to be quashed, then at the very least it would have to take a new decision. But its decision, its pre-existing decision to make those payments would then continue. So it would at that point be an obligation of the local authority to the accommodation provider.
Sorry, maybe I'm being a bit slow. For a period up to October 2023, the landlord of that property was not being paid any rent by anyone.
Yes.
Okay. Right.
Yes. So, well, it's having then shown you Section 19 and the provision that the local authority was, under which local authority decided to provide the accommodation, may I then finish in the Care Act by showing you Section 8, which is on page 3, first page, behind tab 1 of the authorities bundle.
I should have asked this earlier, but the phrase care and support is used a great deal in sections you've shown us. Is it a defined term?
No, there is some case law, which I'm about to come to once I've shown you the section itself. So, Section 8 is entitled How to Meet Needs. So, and you'll see when we come to the cases that accommodation, indeed, none of these ways of meeting needs are themselves needs. They are the ways of meeting the needs that are identified. And one of the ways in which a local authority may meet needs, and this applies to sections 18 through to 20, so including section 19, of course section 18, the main duty section, includes subsection 8.1a, accommodation in a care home or in premises of some other type. And then various other means of meeting needs. And as I will show, my lords, in the case law, that care home or in premises of some other type is a wide and flexible term that can encompass ordinary bedsit or other types of housing accommodation.
What are premises of some other type as distinct from just other premises? Suggests that one is looking at something specific about them, doesn't it?
Well, I absolutely take that point, but there is, as I say, authority that is a wide and flexible term which may encompass, has encompassed the provision of accommodation to, for example, failed asylum seekers with care needs, but not any that don't require any special type of accommodation.
So, could say accommodation in a care home or anywhere else.
It could do. It says premises of.
Could just say accommodation.
It could. My lords will see again when we come to the cases that the, and this is where the legislative history does shed some light, that there was a distinction in, or originally in the framing of the 1948 Act, differentiating between residential care accommodation and, in what was originally section 21(1)b, ordinary accommodation for homeless people. But that then I think the term, we'll come to it in the authorities, but the term that Baroness Hale uses at some stage is the living language meaning developing, so that by the time we get to the 2014 Act, it is well understood that section 21(1)a of the 1948 Act was not so limited. So, my lords, the cases start under the predecessor legislation, section 21 of the 1948 Act, and that is one of the omissions from the original authorities bundle. It's at tab 1 of the supplementary bundle we handed up yesterday.
You don't mean the supplementary bundle?
No, I don't mean the supplementary hearing bundle.
Just so you're aware, we have tabs in the authorities bundle, but we don't have any other tabs, speaking for myself. So,
so I'll stop the unhelpful reference to tabs
right.
in that bundle at page 5.
Yes, right. Yes.
So that is section 21 of the 1948 Act as it stood immediately prior to the coming into force of the 2014 Act, which was on the 1st of April 2015, and you'll see at the top of the page, this was as it stood from the 1st of March 2007 to 31st of March 2015. It's obviously a somewhat differently framed provision, but it provided that subsection 1, that subject to, in accordance with the provisions of this part of this Act, a local authority may, with the approval of the Secretary of State, and to such extent as he may direct, shall make arrangements for providing 21(1)a residential accommodation for persons aged 18 or over who by reason of age, illness, disability or any other circumstance are in need of care and attention which is not otherwise available to them. Now, it's of course right that most cases, certainly most cases that reach the higher courts under this provision, and indeed the equivalent Care Act provisions, are in the context of the exclusionary provision, section 21(1)(a), which is mirrored now in section 21 of the Care Act, which excludes a person who is subject to immigration control from being provided with residential accommodation unless his need for care and attention has arisen solely because he is destitute or because of the physical effects or anticipated physical effects of his being destitute. So there are a series of cases concerning principally asylum seekers and whether they meet that definition. But the focus, firstly, has to be on when the duty arises before one gets to whether or not it's excluded. So under section 21(1), the key words were in need of care and attention which is not otherwise available to them. And you have at tab 5 of the main authorities bundle, page 121, for anyone on the PDF or without tabs. The case of M and Slough Borough Council, in which precisely that question was considered by the House of Lords. And the
I'm sorry, which page did you say? I missed
so
it.
M and Slough begins on page 121, behind tab 5. And you'll see the facts from the head note there. That the claimant had been diagnosed as he was a citizen of Zimbabwe who had remained after his leave expired, so was subject to immigration control, diagnosed as HIV positive, prescribed medication that had to be kept in refrigerated conditions. The local authority, having assessed his needs, took the view it didn't owe him a duty to arrange accommodation under section 21(1)(a), because he was not in need of care and attention. The claimant was successful at first instance and in the Court of Appeal in establishing that his need for to be able to keep his medication in the refrigerator essentially was a need for care and attention. But the House of Lords took the opposite view, and it's summarised there in the head note. Natural and ordinary meaning of care and attention was looking after, meant doing something for a person which he could not or should not be expected to do for himself, and need for a refrigerator in which to keep medication did not amount to a need for care and attention. So this isn't a case about whether or not he's excluded, it's simply a case about not having that need for care and attention. And the reasoning of Baroness Hale begins at page 131, paragraph 30. And she identifies there in the second sentence by letter G, the main issue is the precise meaning of the words in need of care and attention which is not otherwise available to them. As she says, may well be that those who drafted that section assumed it only applied to people who needed extra care and attention which could not be provided in their own homes, and explains that the points I've already referred to about the ordinary homeless being catered to under what was then 21(1)(b. And over the page she refers to her own formulation in the case of Wahid, which is one of the cases that we've put in the supplementary authorities bundle. But the three conditions that she identified there must be in need of care and attention, need must arise by reason of age, illness, disability or other circumstances, and it must not be available otherwise than by the provision of accommodation under section 21. And as she then went on to say, paragraph 33, and this is a passage on which my learned friend relies, but with which we take absolutely no exception, care and attention must mean something more than accommodation. 21(1)(a) is not a general power to provide housing. That's dealt with by other legislation entirely, with its own criteria for eligibility. Simple need for housing, with or without the means of subsistence, but within it, there would have been no need for 21(1)(b). And further, every homeless person who did not qualify for housing under the 1996 Act would be able to turn to the local social services authority instead. Definitely not what Parliament intended. As she says there, just by letter B, I remain of the view, expressed in Wahid, that the natural and ordinary meaning of the words care and attention in this context is looking after. Looking after means doing something for the person being cared for, which he cannot or should not be expected to do for himself, such as household tasks, which an old person can no longer perform or only perform with great difficulty, protection from risks, which a disabled person cannot perceive, personal care, such as feeding, washing, or toileting. He says, that definition draws a reasonable line between the able-bodied and the infirm. So the provision of accommodation under section 21 of the 1948 Act is restricted to the infirm. She puts it there. And of course, the outcome in that case, as I've already referred to, was that the House of Lords concluded that the need to keep medication in a refrigerator did not meet that test. Now, I show my Lords that case because the first case under the 2014 Act, which is the case of GS at tab 6, concludes, and this is then affirmed in the later cases, that the test advocated by Baroness Hale in M continues in effect when one's looking at the equivalent provisions under the Care Act.
GS or SG?
It's SG. So I've put, yes, it is SG. There is a case of GS, they are next to each other, and I had the right tab, but transposed those letters in my note.
And SG came to this court, but they said it was academic. Or...
Yes. So, as set out at paragraph 1 of the Deputy Judge's decision there, on page 143, this was, so far as anyone was aware, the first case to be heard on the accommodation provisions under the 2014 Act. The facts, the needs of the claimant in that case, one can see at paragraph 7 at the bottom of page 143, severe mental health problems including complex PTSD, insomnia, depression and anxiety, and was in need of services to meet her needs for care and support. And there's an extract from a medical letter. Says she requires significant support to ensure good concordance with taking her medication and achieving a good level of nutrition, as some days she simply doesn't eat. Albeit she was accommodated in NAS accommodation, and that was described, she described it in paragraph 8 as reasonably spacious, clean and tidy. She had applied to the local authority for an assessment of needs under the, or for provision to be made in its social services role, firstly, prior to the coming into force of the Care Act in early 2015. So the judge in this case had to consider both schemes, and beginning at paragraph 16 on page 145, he considered the position under section 21 the terms of section 21(1)(a), which I've shown you, the decision in M, which I've shown you, and paragraph 20 quotes the two paragraphs that we were just looking at, and also the later Supreme Court decision in SL, which is dealt with at paragraph 21 of this decision, pages 147 to 148 of the bundle, for the proposition that the need there in SL's case, and one sees this at paragraph 42 of the extract in the middle of page 147, what was submitted to be a looked after need in that case was monitoring SL's condition to avoid a relapse and arranging contact with counselling groups and befrienders. The Supreme Court equally found that that was not a need for care and attention, but also on whether the care and attention would be otherwise available. At paragraph 48 of the extract at the top of page 148. That not only did it have to be a need for care and attention, but it had to be care and attention of a sort which is normally provided in the home, whether ordinary or specialised, or will be effectively useless if the claimant has no home. So the actual analysis that may not be straightforward in any case, and a matter that can be left to the good judgment and common sense of the local authority, but that's what one is looking for, care and attention of a sort which will be effectively useless if the claimant has no home. And having considered those authorities, the judge then went on to look at the 2014 Act, set out some of the provisions there, paragraphs 23 and following, and on the central issue between the parties, which is the provision of accommodation under the Care Act, paragraph 47 on page 153, reiterated that the authorities already considered stand for these propositions, which I think continue to apply under the Care Act. The services provided by the council must be accommodation related, for accommodation to be potentially a duty. In most cases, the matter is best left to the good judgment and common sense of a local authority, and accommodation related care and attention means care and attention of a sort which is normally provided in the home or will be effectively useless if the claimant has no home. The subsequent paragraph, paragraph 48, the deputy judge concluded that in that case, the care plan would have to be redone because there was no evidence there that the defendant had asked itself whether, even if services could have been provided in a non-home environment, they would have been rendered effectively useless if the claimant was homeless and sleeping on the street. So that is the question that a local authority has to ask itself when deciding whether there is a duty, it's under a duty to provide accommodation under the Care Act. Now, the judge rejected the submission. There was only one rational answer to that question, but did find that the local authority had to answer it. In that case, it appears to have been accepted that the test to be addressed under the Care Act was the same as under the 1948 Act. In the GS case, so I think I've got them the right way around this time, at tab 8 of the bundle, it was argued that this was wrong. and that, in fact, care and support under the Care Act was broad enough to include a need for simple accommodation. So tab 8 of the bundle, beginning at page 189, you see in the head note that the claimant was in that case, was a Swiss national, concluded that so not eligible at that time under the Housing Act, concluded that the claimant's need for accommodation was not an eligible need for care and support under the 2014 Act, and he sought judicial review of that decision. And the issues that arose for determination included, at 1, whether a need for accommodation was a need for care and support under the 2014 Act, and one sees at paragraph 21 on page 197 of the bundle, in the second sentence just between A and B.
Sorry, I'm just reading the paragraph 1 of the head note. Yes, sorry.
So,
which paragraph?
So on Lord will see from the head note that SG was followed. The first paragraph to which I invite my Lord's attention is on page 197, paragraph 21. And just to identify that the argument that was being run there in the second sentence by Mr. Burton on behalf of the claimant was that the cases under the National Assistance Act were no longer relevant, and that care and support had a different meaning to care and attention, and that SG was wrongly decided, and the Deputy Judge in that case didn't have to follow it. That submission was rejected, having again reviewed the authorities that we've to some extent already discussed. At paragraph 28, beginning on page 199, the sidelined passage. The judge found that a need for care and support did not include a need for just accommodation for the following reasons. Ordinary meaning of care and support does not include accommodation on its own. That Section 8 was of no help because it was simply an example of how needs were to be met and reflects the outcome of the cases previously decided under the National Assistance Act. So the straightforward reference to the care home there and other accommodation didn't mean that other accommodation, absent the need for other services, was brought back in, the old Section 21(1)(b) effectively. Then talks at 3 about eligible needs, and at 4 about the fact that other legislation exists to provide accommodation for those in need of it, and I will of course come back to that point. But the core of the decision there is on paragraph 29, page 200. Need for care and support does not include a need for accommodation alone. Agree with the conclusion reached in SG's case on the applicability of the authorities under the 1948 Act in relation to the meaning of need for care and attention. It excludes need for accommodation alone, and this applies to the phrase need for care and support as it appears in the Care Act 2014. Of course, as he goes on to say, care and support is a different phrase and may mean something different to a need for care and attention, but in my judgment it does not include a need for accommodation alone for the reasons that I have given. Now, my Lord, just on that point, my Lord Justice Dean, I think, asked about whether there was any definition of need for care and support. It's right that there isn't. There is relatively recent authority in this court, the final case in the bundle, tab 12, BG and Suffolk County Council. And that is...
Page...
Sorry, begins at page 269.
Yes.
That concerns somewhat different circumstances of whether the provision of respite holidays could come within the provision that could be made under the 2014 Act. On this point, specifically about the meaning of care and support, at paragraph 70 on page 286, this is Lady Justice Nicola Davies giving a judgment with which both other members of the court agree. She says there that one can, in the second sentence, contrast the phrase care and support with care and attention to be found in the predecessor legislation. And she says that it was care and attention which was interpreted by Baroness Hale and M as referring to looked after needs, in inverted commas, except that such a phrase does reflect the concept of care and attention. In my view, it does not reflect the development in the approach which local authorities are now to adopt, as set out in sections 1, 9 and 18 of the 2014 Act, which recognise the autonomy of the individual and the need for care and support. In my judgment, the needs under the 2014 Act can no longer be described as looked after needs, as such description does not properly reflect the individual nature of the assessment. And at paragraph 71, I read the intention of the legislation as being to broaden the discretion and flexibility of local authorities in their provision of care and support to adults. Now, I don't ask you to go beyond the authorities that I'm showing you in terms of when there would have been a need for care and attention justifying the provision of accommodation under section 21 of the 1948 Act and reading that across to the 2014 Act. What I do rely on that for is to say that it's certainly not narrowed. That is authority at the level of this court for the proposition that, at the very least, if there was a need for care and attention under section 21, there would be a need for care and support under the 2014 Act. So the final case then in this run of cases on when accommodation may be provided under the 2014 Act is the case of Aburas at tab 10, beginning on page 232, the bundle of authorities. And this is where we get the somewhat inelegant but potentially helpful phrase accommodation plus. From
that was an invention of Miss Mallock in the Aburas case.
Yes, adopted by Mr. Justice Fordham, as
yes.
he now is, sitting there as a deputy. And that, as Mr. Justice Fordham identified at paragraph 1 on page 233, was a case about local authority functions of assessing and meeting needs for care and support under the Care Act, and then what authorities can be required to do even when they don't have those duties, where they are required to exercise those powers and duties in order to avoid a breach of human rights. The key factual features are set out at paragraph 2. Mr. Aburas was a stateless Palestinian who had mental health issues, including bipolar disorder and depression, failed asylum seeker without regular immigration status. And so, again, the question arose, this time under the Care Act, about whether the local authority was under a duty to provide him with accommodation. So the legal framework was dealt with beginning at paragraph 5 on page 236. As it's put at paragraph 5, in asking and answering some key questions to describe the statutory scheme. First, what are relevant needs for the purposes of the 2014 Act? The answer is that they are, inverted commas, looked after needs. It's a statutory scheme for assessing and meeting needs for care and support. That idea was well recognised in the predecessor legislation. And again, we have Lady Hale in M. And then at paragraph 6, the relationship between the 2014 Act and the duties to provide accommodation. And the answer given, and again not controversial in this case, is that the need for accommodation is not itself a looked after need, but the provision of accommodation may be called for under the 2014 Act so as to secure effective care and support for a looked after need. In other words, accommodation may be assessed to be the necessary and appropriate conduit for the practical and effective delivery of care and support for the relevant looked after needs. It's important to look at accommodation needs through that prism for the purpose of the 2014 Act statutory functions. And paragraph 6 sub 2 and 237 Council were agreed as to when it is in essence that accommodation comes to be appropriately provided pursuant to the 2014 Act. They agreed this is so when the person has a looked after need of care and support whose effective delivery requires accommodation. That's then where the phrase accommodation plus is taken up. And at subparagraph 2, it follows that what the Care Act is not concerned to do is to deal in any other or more general way with accommodation or accommodation needs. Takes the example of Bernard and Enfield, which is also referred to in the case of Adolo, which of course I'm going to have to come to, and which we've put in the supplementary bundle. Notes that in that case, Bernard, the care needs were those of Mrs. Bernard, a person with severe disabilities, and addressing those needs gave rise to a statutory duty under the equivalent legislation, so under the 1948 Act, to provide suitably adapted accommodation whose denial on the facts of that case was a breach of Mrs. Bernard's convention rights. And then at subparagraph 4, there is reference to section 23 and boundaries between the statutory schemes, as identifying the boundaries between the statutory schemes. It would undermine the integrity of a coherent statutory framework if the 2014 Act became a backdoor route to claims based on accommodation needs, circumventing the scheme of the 1996 Act and jumping the homelessness queue. So it's not, and this is the purpose really of taking my lords to these cases to establish the constituency we're concerned with, it's not about anyone who needs housing and that's their only need. Those people absolutely are dealt with under the 1996 Act. It's not people who have needs for care and support, what's previously called care and attention, looked after needs, if you want to describe them, that are unrelated to accommodation, and that's the authority of SL. It's only where a person requires specific action to address a need for care and support, and accommodation is required for the effective delivery of that support. And going back to, get these letters the right way around, going back to SG, that is the question the authority has to ask itself. Can the care and support which is required be effectively delivered in the absence of accommodation? And if not, that's when accommodation may need to be required under the Care Act to to meet the needs for care and support. Now, so far, and up to that point, the identification of whether there could be a need, no difference between those subject to immigration control, those with medical needs, those who are eligible under the, or owed duties under the 1996 Act.
Well,
But there are then...
Can we just postpone the question of people subject to immigration control and just take the very large constituency of people who are not, but who have potentially a need for care and support under the 2014 Act, and assume they don't have their own homes and they're in difficulty in obtaining rented accommodation. Do they all qualify for accommodation as part of a package of care and support under the 2014 Act?
They do, unless they are owed a duty, so unless the housing authority is required to provide them with that accommodation under the 1996 Act. So it does come to the question that is the next in my agenda, so to speak, item 2, what the duties are under the Housing Act. But the submission that I wanted to make just very briefly is that the test, the analysis of when accommodation may be the appropriate means of meeting the needs identified under the Care Act is the same for all categories of person. It's just that there are then, after those provisions, a series of restrictions on what may be done under sections 18 to 20 of the Care Act. And those are firstly section 21, which you have at page 9 of our new authorities bundle.
Section 21.
Section 21 of the Care Act 2014, page 9 of the new authorities bundle.
Yes, all right. We
So-
know about them.
So that exactly mirrors 21(1)A.
Yes.
And then you have section 22, which provides that the local authority may not meet needs under section 18 to 20 by providing or arranging for the provision of a service or facilities required to be provided under the NHS Act 2006. Okay. And you have section 23. And all of those mirror, section 21 mirrors section 21(1)A of the 1948 Act. Sections 22 and 23 mirror, I think the term used in the explanatory note that my learned friend referred to in his summary grounds of resistance is replace section 21(8) of the 1948 Act. And that's on page 7 of the bundle of authorities. Nothing in this section shall authorise or require a local authority to make any provision authorised or required to be made, whether by that or by any other authority, by or under any enactment not contained in this part of this Act. It's, I think, slightly curious phrasing, not limited to the Housing Acts there, and potentially by the time we get to 2014, past 2011, rather prohibits the local authority from doing anything under section 21, but that's not a point that was ever taken in relation to the general power of competence. But there was equivalent provision under section 21(8) of the 1948 Act, so the structure is effectively the same, albeit it's more clearer to follow in the new legislation, that you assess you establish whether there are eligible needs. Ways of meeting those eligible needs may include the provision of accommodation in an accommodation plus type case, but if the applicant is subject to immigration control, you have to get past section 21. If the needs include medical provision, then there may be some quite active debate between local authorities and ICBs as to who's responsible for providing that under section 22. And if the need involves accommodation, again, the delineation between what the local authority, the ultimate duties of the local authority and the housing authority is provided for by section 23. Now, to fast forward to what I say about section 23, I say that that's like section 22, there to draw that dividing line. So where you have an identified need, the health service can't decline to put healthcare provision into an accommodation placement because there's a duty under the Care Act. And a housing authority can't, for example, say that a person doesn't qualify under Part 7 of the Housing Act, which we'll come on to in a moment, as homeless because of accommodation being provided under the Care Act. Because the statutory dividing line, the allocation of responsibility, is that where a duty is owed, where a local housing authority is required to do something under the Housing Act, then the local social services authority is not required to relieve them of that duty. Cannot be required to relieve them of that duty.
Under Part 7 of the Housing Act 1996, is it too simple to say either somebody is homeless within the definition of that part of the Act, and I appreciate that doesn't mean necessarily on the street. Either they are or they're not, and if they are, then don't they? In other words, if the accommodation they are in at the moment is so substandard, use an inadequate summary phrase, that they are to be considered homeless within the meaning of the Act, then don't they qualify?
Well, Lord, it's rather more complex than that, and I was about to come on to the 1996 Act.
All right, well, you come to it in your own time.
I just wanted to touch very briefly, because it's actually the basis on which the decision went against my client at first instance on Part 6 of the 1996 Act. So, if I might show my lords that, it's behind tab 2 of the main bundle of authorities. And you have, first of all, section 160ZA, just to establish eligibility. No controversy there. My client is eligible, or is not ineligible, and that's the actually the way in which it is set up. You are eligible if you're not ineligible, and he is not within any of the categories of person who is ineligible. The main category there, of course, being persons who are subject to immigration control. The duty then under section 166A of the 1996 Act, which is to be found at page 28 behind the same tab, is firstly in subsection 1 there to have an allocation scheme for determining priorities and the procedure to be followed in allocating housing accommodation. That scheme must, by subsection 3, secure that reasonable preference is given to A, people who are homeless within the meaning of Part 7, and D, people who need to move on medical or welfare grounds. And by subsection 14 on page 30.
I mean, there's a clear overlap there, isn't there? Because people who need to move on medical or welfare grounds are quite likely to be people who need care and support.
Well,
and therefore, all they get under section 166A is a scheme which gives them reasonable preference.
well, they may or may not be people who have needs for care and support. And
Well, they may not be, but quite a lot of people who have a disability, for example, which is specifically referred to, may need care and support to help them with that disability.
Yes, may do, but it's not. It's not the same statutory test, and this is about the allocation of the local authority's housing stock, the stock that it has available to it for. And as I was saying, under subsection 14, the local housing authority in England shall not allocate accommodation except in accordance with this allocation scheme. So what a local authority is required to do under Part 6 of the Housing Act is to have an allocation scheme and to abide by it. So to not make offers of accommodation other than in accordance with that allocation scheme. And we will see when we come to Adolo that even being in an urgent band with the highest priority, in I think 2 high priority cases in the borough in that case, it took 6 months for a property to be identified through that route. And the position under Part 6 of the Housing Act is that if nothing comes up that's appropriate to be, or that the applicant is entitled to have allocated to them, then they don't get anything. So you can be on the housing register for very many years and not obtain any housing at all. Now, that arguably people who need to move on medical or welfare grounds might be thought to encompass people who already have accommodation anyway, because what we're actually principally concerned with here is where there may be a need to provide accommodation because otherwise, under the Care Act, because otherwise the care and support that person needs cannot be effectively provided, will be rendered useless.
Well,
So
that begs all the questions in the case, doesn't it? That way of putting it.
But, my lord, it's unquestionably the test for when accommodation can ever be provided under the Care Act. It begs the questions in this, in the sense that it begs questions in this case because it's not been assessed. So I will come on to show you what the needs are, and my submission will be that it is at least likely, at least plausible, that a proper assessment would determine that those needs could not effectively be provided for if the appellant was homeless. But that's not a question the authority's ever asked itself, because every time that it assessed him, as I'll come on to show you, he was in accommodation, so it didn't consider the question. But under Part 6 of the Housing Act, there is no requirement to provide him with anything unless effectively his number comes up on the ballot. But the allocation scheme leads to a property being allocated to him. And I don't think it's in dispute. I think my lords setting the point.
What do you say required to provide means?
I say that realistically, in terms of what one has to look at is what would the authority be providing, and is that something, so what would the local authority otherwise be required to provide under the Care Act, and is that something that the local housing authority is required to provide under the 1996 Act. Now, in this case, the local authority is not required to provide anything under Part 6 of the 1996 Act. It's required to enable him to bid with the priority that attaches under Band B for such properties as come up. But it is equally entitled to leave him if no such properties come up as part of the general housing process.
But what do you say required to provide means?
It means precisely that, required to make accommodation available for his occupation.
As it were, today?
Yes.
Well, is anybody ever, is a local authority under Part 6? Part 7 may be different, but is a local authority ever required to provide accommodation to anybody in that sense?
Under Part 6, well, outside particularly exceptional cases, of which cases like Adolo may actually be one, no. But what Section 23 doesn't say is that a person who is eligible for assistance under the 1996 Act is thereby disqualified from being provided with accommodation. What it says is that the local social services authority may not provide that which the local housing authority is required to provide. Now, we know that in this case, the appellant lawfully has not obtained accommodation through Part 6. The local housing authority is not required to ensure that he has accommodation. Now, and what I say is that in a case where, in order for his care needs to be met, he requires accommodation, that's question one. And that's the first question that would need to be addressed on a proper assessment. If that is the case, and if the local housing authority, as my lord quite rightly says, is not required to provide that immediately under Part 6, then the statutory exclusion in Section 23 doesn't point.
Well, when does it ever apply?
It would apply in a number of situations. So, firstly, where he did have accommodation, where his care and support needs could be provided for, the support wasn't rendered effectively useless, but where he was entitled, where he was, through the Part 6 process, seeking to obtain accommodation in which those needs could be better met, for example. And that may, in fact, and then we'll come on to it, have been the situation in Adolo.
Well, can we just look at Section 23?
Of course, it's back in tab 1.
Yes, page 21.
On page 21.
May not meet needs by doing anything which this or another local authority is required to do under the housing. Now, in what cases is a local authority required to provide accommodation immediately?
The only case under the Housing Act in which the local authority is required to provide accommodation immediately is under Part 7.
Yes. But is that case a problem? Because if somebody, let's take the easiest case, perhaps somebody who is street homeless and not excluded by the immigration provision. Somebody who is street homeless is surely entitled to be provided with accommodation under Part 7.
Well,
and Section 23 has got nothing to do with it.
Well, can I take you to Part 7? Because it's actually
Yes.
the mere fact of...
Just before we leave Section 23, though, if your submission is that somebody who requires accommodation for their care needs to be met, but who the local authority is not obliged to provide accommodation for under Part 6 because they're not obliged to provide accommodation to anybody under Part 6, that does mean, doesn't it, that a person who has care needs for which accommodation is needed jumps over people with a higher priority under the Part 6 scheme. Because under the Care Act, they've got to do it, and they've got to do it, if not today, then almost straight away, even if there isn't any accommodation available in the borough, whereas the person who is at the very top of the Part 6 scheme has to wait for something to come up for which he can bid.
Well, yes, I say that.
Yeah.
So, but subject to one caveat and to one reason why that should be the case. Now, the purpose of Part 6 is not just meeting needs. It's allocating housing according to priorities and preferences. So it may be that in most cases you're not going to get, almost every case, you're not going to get much priority unless your current housing is overcrowded, but there will be people within the Part 6 system simply waiting for a larger property to move into, or actually waiting for a smaller property to move into because children have left home and things of that nature. So it is about that general allocation of housing. And what you can't do under Section 23 would be, for example, take someone who is in accommodation where they're receiving care and support services, who wants to move to a smaller property, for whatever reason it's more convenient, and allocate them that if they wouldn't be entitled to it under the Part 6 scheme. So the integrity of the Part 6 scheme is preserved. But that is subject to people not being left in a situation where they have a need for care and support that cannot effectively be provided if they are street homeless, or potentially in the accommodation in which they're in. And that I don't shy away from that. I mean, effectively, I didn't take you to the passage in M, but I think it was Lord Justice Simon Brown in a case that was then quoted by Baroness Hale in M, said, if there are to be immigrant beggars on our streets, then let them not be old, ill or disabled. It's if people are going to be left street homeless or in accommodation that is less than ideal for them, let them not be additionally unable to have their care needs met. I mean, let the street homeless not be old, ill or disabled, effectively, where we are with this. And there will, in many cases, I'll come on to show you, under Part 7, be a route whereby they will get housed by the local housing authority. So this is a fallback provision. This is the safety net for the disabled whose care needs are such that they require the provision of accommodation so that they can be met.
But putting aside people who need to live in a care home, which is not what this case is, how do you draw a bright line between people who terminology of section 166A of the Housing Act, are people who need to move on medical or welfare grounds, not just would like to move, including any grounds relating to a disability. And people who require, quote, care and support within the 2014 Act.
So, well, I'd ask for a bright line, and that can be quite difficult in legislative schemes of this nature. But the line is between those who are within the Part 6 allocation scheme, which is only for the allocation of social housing stock, so where the local authority is the landlord, and are waiting for social housing to become available. And those who have needs, Care Act needs for care and support that cannot otherwise be met. Now, if those people are already in accommodation, and that's actually not quite the facts with which we're presented, because although my client has always had accommodation, it's because it was provided under the Care Act. He would otherwise have been street homeless. And that's really that's where this issue arises. He's not waiting to move, looking for under Part 6. He is, at the time that he presents to this local authority, at risk of street homelessness, and has Care Act needs, which they presumably, at least at that time, thought may require the provision of accommodation. That's why they provided it under section 19.3. Now, say Part 6 is concerned with the allocation of the general housing stock. Part 7, which I'm about to come on to, and the 2014 Act, cast the net much wider, because they aren't about who has to get the housing stock that we've got. They are both provisions that mean that accommodation must be provided, even if it's not, wouldn't otherwise have been available. The authority has to go and procure it.
Maybe in the private sector.
Maybe in the private sector,
yeah.
as they did in this case, by placing
Yes.
it in a B&B. And that's not something that could happen. So what, in a sense, it's a bit circular, because actually what the local authority did for this man, place him in a B&B and pay the rent, is not something they even could do, let alone be required to do under Part 6 of the 1996 Act.
But if he would indeed have been street homeless otherwise, they could have done it under Part 7.
Now, my lords, we're rather dancing around Part 7, so shall we look at
Yes.
this? I think that may be
So,
now may be a good moment. The first provision that we have from Part 7 is on page 31 of the main authorities bundle, still behind tab 2. And you have there at section 175 the definition of being homeless. So, no accommodation available for his occupation, or the accommodation, this is 1753, not being accommodation which should be reasonable for him to continue to occupy. And threatened with homelessness if it's likely to become homeless within 56 days. Also homeless by virtue of 1752, although not relevant here, if living in a movable structure or vehicle and doesn't have a place to park it. So that's homeless, but homeless, as we'll see, is not the only qualifying criterion for being assisted, certainly being provided with accommodation under Part 7. So we then have at section 184 on page 33 If the local housing authority have reason to believe that an applicant may be homeless or threatened with homelessness, they're to make such inquiries as are necessary to satisfy themselves whether he is eligible, and eligibility again is defined in section 185 over the page as excluding persons from abroad, obviously not excluding the appellant. So that's the first inquiry. And if eligible, whether any duty, and if so, what duty is owed under the following provisions of this part. So there are a range of duties, and it's perhaps also worth noting that those duties are owed to an applicant, not a person. There has to be a person who has applied to the local housing authority for assistance. So there's then potentially an interim duty to accommodate in cases of apparent priority need. So it's section 188 on page 37. If a local authority has reason to believe an applicant may be homeless, eligible for assistance, and have a priority need, they must secure that accommodation is available for the applicant's occupation. So interim duty if firstly homeless, secondly eligible, no issue with that here, thirdly priority need. And priority need is defined in section 189 on page 40 and includes a person who is vulnerable as a result of old age, mental illness, handicap or physical disability, etc. So again, one might expect a good deal of overlap between that constituency and those who have needs for care and support under the Care Act, albeit that you have in the authorities bundle, not a case I've shown you because I don't think it goes to any proposition that I understand to be in dispute, but the case of Antoniak at tab 9, where a paralysed wheelchair user was found not to be in need of care and support for the Care Act purposes, but nonetheless one would expect that person to fall within the definition of priority need. So it's not the same test. Now, what you also have under Part 7 is the definition at section 191, page 42, of becoming homeless intentionally. And the person becomes homeless intentionally if he deliberately does or fails to do anything in consequence of which he ceases to occupy accommodation which is available for his occupation and which it would have been reasonable for him to continue to occupy. Now that typically, not exclusively, but typically includes cases where people have been evicted for not paying their rent. And without making any concessions at all, I'll also have picked up from the papers that is something that features in my client's history. It's not something there's been determination about, but it is there, and it is something that would have had to be considered on any homelessness application that he made. Now,
I'm not sure whether this is relevant in this case, but are you saying that people occupying accommodation under the Care Act are effectively exempt from this?
I don't say effectively exempt because there will be circumstances in which the Care Act duty is discharged. But I do say that the Care Act duty, as I've already indicated, is a kind of a safety net duty for what might otherwise be the disabled homeless. And that there will be cases where a person, and so the main housing duty, section 193 on page 44, which is a duty to see subsection 2 to secure that accommodation is available for occupation by the applicant. So that is the housing duty. That applies, subsection 1A, where the local housing authority is satisfied an applicant is homeless and eligible. So firstly homeless, but not having a home or not having a home as reason to occupy. That's the first condition. Eligible for assistance, know about that. Not satisfied the applicant became homeless intentionally. Are satisfied that the applicant has a priority need. So all of those have to be determined by the local housing authority, and all of them are subject to the local housing authority being satisfied of those matters. So it's not as I'm sure my lord didn't mean to give this impression, but it's not a binary, you're on the streets and you're homeless, therefore you're entitled to accommodation. There are a number of hurdles to overcome, even if one is homeless, before one is entitled to be provided with accommodation under section 193.
So your case then, if I've understood it, is that somebody who is homeless intentionally, so that there is no Part 7 duty on the local authority, is still entitled to accommodation under the Care Act if his needs are accommodation related. Is that right?
So that isn't excluded by section 23, because no authority is required to provide him with accommodation under the Housing Act. Now, that doesn't mean...
Your submission is that somebody who has accommodation-related needs satisfies the Care Act duties subject to section 23, and if they are homeless intentionally, no Part 7 duty, therefore the Care Act duty arises.
Yes.
Yeah, I just want to understand it, that's all.
Can I just ask on that? I mean, what care needs could be provided which don't require accommodation?
My lord, that's going to be a fact-sensitive duty in each case. But for example, I think in the case of, I showed you some quotation from the case of SL, where there were needs relating to befriending and taking to appointments, things of that nature, which are care and support needs under the Care Act, but not accommodation related.
But he's going to be taken to appointments and then just dumped back on the street?
That's the import of the Supreme Court's decision.
And for any duties to arise under the Care Act under section 18, which might include accommodation, you have to go through the financial assessment.
You do have to go through the financial assessment. And yes, so for that duty to crystallise. But
So your case is very narrow. There was a power under 19.3 which was discretionary.
yes,
He'd refused to have any financial assessment, so section 18 didn't apply.
well,
It couldn't apply until you have the assessment. And if he'd have been told, well, this is going to be the position, he might have agreed to have the financial assessment, and section 18 would be true.
well, it's rather different to that, because he didn't require to have the financial assessment, because the identified care and support needs for assistance with dressing, etc., were going to be met by his family members, and therefore under section 18.7, if those were the only needs, no duty under section 18 would arise. So what we say the vice is here is the local authority does appear to have identified a need for accommodation in 2016. When it assesses under the Care Act, it doesn't consider whether there is an accommodation plus need of the needs for care and support could be delivered if he doesn't have accommodation. And so it can't then withdraw that support without conducting that proper assessment.
But if the care needs were being met by his family, if he loses his accommodation, if you're being brutal about it, which I'm afraid the statutes rather are, he can walk to his family home and get whatever dressings are required to be changed. That's why I asked you about what needs could be met on the street.
Well, I was planning to show you at later stage the Care Act assessments, such as they are, and what the needs are. But they're not limited to changing of dressing. They include dressing and undressing, washing, assistance with preparation of meals, assistance moving around accommodation, assistance keeping tidy. They are, by definition, needs related to being in and having accommodation, precisely the type that have been identified as needs that could not be met without him being in accommodation. I also don't have to persuade this court that his needs are accommodation plus. What I say in this court and said below is that the local authority has not asked itself that question. It is required to ask itself that question. And that's what the GS case says. That a person who has needs that on their face are accommodation related, and they are on their face accommodation related, on the needing assistance in the home side of the line versus the befriending and taking to appointment side of the line, and that seems to be the line that emerges from the Supreme Court House of Lords authorities, then those needs, then the authority is required to address that question, to ask itself the right question.
To say that needing to keep your accommodation tidy is an accommodation-related need sounds like putting the cart before the horse to me.
There is a particular issue here, of course, with visual impairment and needing to be able to move around safely. So I think perhaps when I said tidy, I was belittling the ability to keep it in a state where he could move around safely.
But accommodation plus is, I think we're agreed, it's not a phrase in the statute, it's a phrase which Miss Malik floated in the Aberras case, and Justice Fordham found helpful. But I find it very difficult to see that much of care and support is not accommodation related. I mean, you give an example of befriending and accompanying to appointments, but that's a tiny, tiny, tiny part of the needs of people who have needs for care and support.
I certainly accept that there will be a large constituency of people with needs for care and support whose needs for care and support cannot be met if they are not in accommodation. Most of those people, if they are not excluded from the provision of accommodation under the Housing Act, they're not ineligible under the Housing Act, by reason of being subject to immigration control, are likely to have access to accommodation so that it is not a need that needs to be met.
I mean, the typical things which a carer does, helping somebody to dress, to wash, to go to the toilet, cooking a meal for them, all assume accommodation.
Yes, and my lords, I mean, I don't shy away from my submission that the purpose, the end result that I'm arguing for is that people who are not able to wash and dress and toilet and feed themselves should not be street homeless, even if they are people who would otherwise fall through the gaps in the Housing Act.
Can I just ask you this question, which is where you are in a property that you don't like, and we know from all the housing cases that there are people in those situations, that you have a care need, and you deliberately then stop making the payments, so you take yourself out of the homelessness provisions in Part 7, and then you say, I have a need for accommodation, and it's not being met.
So, my lord, all of these cases are going to be fact specific. I mean, what we have said in our skeleton argument is that we're not arguing that this isn't a requirement to provide accommodation indefinitely. to make sure I find the... Yeah, so paragraph 42 of our skeleton argument, we say that a care plan might in principle make provision that the appellant's accommodation plus needs should be met by an application for homelessness assistance, for example, and that he should be provided with the appropriate support to make that application, but there would need to be safeguards, including consideration as to what was to happen if it transpired that the main housing duty was not owed.
Picking up my Lord's
So
point,
that-
under the Housing Act, there are protections for somebody who doesn't like the accommodation they've been provided with
Yes.
because of the requirement of suitability,
Yes.
which can then be challenged in the
Yes.
county court.
Yes.
There's nothing equivalent under the Care Act, which rather suggests that the Care Act is simply not concerned with that kind of accommodation question, doesn't it? Because otherwise there would be some provision equivalent to the suitability protections.
But the Care Act is concerned with what is necessary to meet needs, eligible needs for care and support. So that is, I accept, of course, a different question to whether accommodation is suitable under the Housing Act and whether one could succeed in a Section 202 appeal and all of those questions. It isn't. It is a come back to
But
care safety.
suitability under the Housing Act will often encompass questions whether it is suitable to meet the particular needs
Yes.
which, for example, a disabled person has.
Yes. But that is, with respect to a somewhat different question to whether, because the accommodation itself is not a need that is being provided under the Care Act. The accommodation is what is necessary in order for the support that is required to meet the needs under the Care Act to be effective, to not be rendered useless. And it's, I mean, to go back to my Lord Justice Bean's point about what's accommodation plus mean in the term, it's shorthand. It's shorthand to avoid having to say on every occasion the services that would be required to meet his care and support needs would otherwise be rendered useless, or some other words emerging from the judgments in M and SL. So it's not, and that is a different question to suitability. It may be more than possible, and indeed in this case, what's being provided, and we would say is necessary to be provided in order to enable the care and support needs that have been identified to be met, is a room is a bedsit in a shared house. Now that's not something that would ordinarily be deemed suitable, certainly under, it's not something that's likely to be allocated under Part 6, and it's not the sort of accommodation that he would be bidding for under Part 6, and it's the sort of accommodation that might be provided on a fairly short-term basis under the Housing Act, but would it be, if this is what he was provided, in the theoretical world in which he had applied for and been found to qualify for the main homelessness duty, would this be suitable accommodation? Quite possibly not. That's a different question. Is it sufficient to ensure that the services with which he's being provided are not rendered effectively useless?
So you define the non-statutory defined term accommodation plus as being what accommodation which is provided because without it the care and support services to which the claimant is entitled would otherwise be rendered useless. Perhaps that's another way of saying can only be rendered in somebody's home. But as Lord Justice Mayles put to you, that applies to pretty well all the core services provided by carers.
I say, I don't shy away from that, because what has to be shown is that there is a need for those services. So if there is a need for a person to be assisted with all of the activities of daily living in the way that carers generally do, then that person does require accommodation in order for that care and attention not to be rendered effectively useless. And that is the terminology used in the Supreme Court. So it's not. I understand my lordship's perhaps difficulty with the breadth of it, but it's not a term that is generated in this case, or indeed in the first instance cases that I've been showing you under the Care Act. It's from the House of Lords and then Supreme Court in Slough and then in SL. And danger of repeating myself, I think the group we are concerned with are those who cannot look after themselves without those services being provided. And a group who will, it is a relatively narrow group, isn't it? A narrow group of those who are eligible under the Housing Act but don't otherwise have access to accommodation for those Care Act services to be provided at the moment, at the time at which the assessment is being conducted and the care plan developed. Now, as I say, I come back to what is a housing authority required to provide under the Housing Act. It's required to provide under Part 6 an allocation scheme and allocations in accordance with that scheme. There's no question that what the authority would be providing here has been providing here is cutting under its, what are in this case its separate functions as housing authority, and of course it won't always be the same authority. It just so happens that it is in this case, but there is no provision under which, so yeah, there's no provision under Part 6 of the Housing Act that does or could require the local housing authority to make a property available to ensure that care and support can be provided that would otherwise be effectively useless without a home. And perhaps it is worth just focusing again on those words. Care and attention of a sort which is normally provided in the home or will be effectively useless if the claimant has no home. It's not about whether the home is...
What's that a
That's
quotation?
a quotation from Lord Carnworth in SL, which is itself quoted by the Deputy Judge in SG, page 148 of the Main Authorities Bundle.
Yes. All right. Now we probably ought to let you make some progress, and in particular, you as you recognise, are going to have to get to Idolo, either via Aberras or without it. But at some point, you have to show why Mrs. Justice Collins Rice, as she then was wrong.
Of course, my lords.
Yes.
So I was just picking up where I was in the scheme of my submissions.
Yes.
The submission in relation to the Housing Act is, as we say in paragraph 38 of our skeleton argument,
Yes.
neither the judge or the respondent has identified any provision under which there was a duty to provide accommodation to the appellant on the facts of this case. The judge dealt with it at paragraph 57 of the judgment, which is behind tab 6 in the core. No, it's not, it's behind tab 7 in the core hearing bundle.
Yes.
Page 81. And he says there that sets out his conclusion that the defendant is and wasn't material time required to provide the claimant with housing under the Housing Act, because he was a qualifying person under Part 6, which must mean he is eligible.
You disagree with the first sentence?
I disagree with the first sentence.
Yeah.
And I disagree with the first sentence because, as I've shown you, there is no requirement under Part 6 to provide accommodation. There is a requirement to have a housing allocation policy and to allocate housing in accordance with that policy.
So
It's not to give rise to.
your submission is that there is never a duty under Part 6, and therefore Section 23 of the Care Act must be read as referring exclusively to such duties as arise under Part 7.
It is possible to hypothesise a situation in which the allocation system is not being properly operated under Part 6, for example, so that a person has a claim against a housing authority that they are in fact required to allocate and offer them a particular property which they have not been allocated or offered. But beyond that, no, there is no requirement under Part 6.
Can I just ask you, because you quite rightly said these turn on their own facts. On their own facts, we know that your client had been offered various bids, made bids, and also been offered accommodation. Does that not, in the particular circumstances of this case, show that there was accommodation being required to be offered under Part 6? There may be theoretical cases otherwise where you're not high enough up, but he was.
Well, making bids with respect doesn't tell one anything, because unless the bids are successful,
Yeah.
you can make as many bids as you want and not get anywhere. The direct offers he didn't consider were suitable, and the local housing authority wasn't required to do that. It did that. It retained, as I think my learned friend puts it in his skeleton, a power to do that, but it wasn't required to make those offers.
But it did, and it was under the Housing Act.
Yes. But it's not something that it was required to do.
Once a local authority makes an offer which is refused, that discharges the duty, doesn't it? So that there is no duty thereafter. So presumably you would say the very opposite to what my lord put to you, that once somebody refuses an offer under the Housing Act, there's no duty under the Housing Act anymore, and therefore they qualify under the Care Act.
That is a circumstance in which whether it is necessary to provide accommodation for them under the Care Act would need to be considered as part of the care planning process, yes. Because I do need to be very clear about the extent of my argument in this case. It is not to say that every person in my client's situation must be provided with accommodation under the Care Act and must be provided with that accommodation indefinitely. The only, in terms of the appeal, the basis on which the appeal was, the judicial review came, was decided against my client, was that Section 23 was an absolute bar to the provision to him of accommodation under the Care Act, notwithstanding that it had been provided under the Care Act for a period of 6 years. Now, that's,
I mean, your submissions, putting it bluntly, seem to ride somewhat roughshod over the various checks and balances in the Housing Act, such as that if you refuse an offer, then the council's duty is discharged, such as that if you're intentionally homeless, there's no duty under Part 7. In other words, almost the worse you are, worse position you're in under the Housing Act, the better position you're in under the Care Act.
My submission is only that if you are not owed a duty under the Housing Act, there is no requirement under the Housing Act to house you, that Section 23 does not then prevent, Section 23 does not prevent you being provided with accommodation under the Care Act where that is necessary in order for your care and support needs to be met. Now, the local authority may, as we've said in our skirting argument, look at a number of ways of discharging that duty. It may provide accommodation, it may not be under a duty to do so on the particular facts of a case, and that hasn't been considered by the authority in this case. It hasn't asked itself that question. So I am not seeking to persuade your lordships that all of this constituency of the disabled homeless ought to be provided, must be provided with accommodation under the Care Act. I'm saying that in an individual case where a local authority, social services authority, is presented with a person with needs for care and support that cannot be met unless they have accommodation, and that person is not at the time owed a duty under the Housing Act, and that may be because they haven't applied, for example, in which case they may need to be supported to make that application. It may be because they have applied and been found to be intentionally homeless. That may be because of reasons that the local authority considers to be understandable in the light of their disability. It may not. It may be that they've been evicted because of antisocial behaviour, and that factors into the planning of what the local authority will do. All I'm saying is that there is no bar there on the local authority considering those matters. And I've shown your lordships the cases about the disabled homeless because that's where the power to provide the duty, to provide the accommodation comes from at all. And my intention, which perhaps was slightly misjudged, was to demonstrate to your lordships the relatively narrow category of circumstance we're talking about here. Because while, yes, in absolute terms, perhaps might be said many people have disabilities, needs for care and attention, it is a relatively small subset of the population that is disabled and doesn't otherwise have access to a home in which services, the care and support they need can be provided. And in those cases where no duty is owed under the Housing Act, a local authority can consider whether providing accommodation is the appropriate response to meet those needs. That's as far as my argument on that point goes. So on the judgment, I say paragraph 57, the judge is simply wrong at paragraph 57 to say that the fact that the defendant has not provided accommodation to the claimant, well, you might be right actually to say that the fact that the defendant has not yet required accommodation to the claimant under Part 6 of the Housing Act does not mean that it is not required to do so. Simply Part 6 of the Housing Act doesn't require it to do so. What Part 6 requires is that the allocation scheme is operated, and if the claimant is then successful in his bid, he will move in and have his rent paid through whatever means is available to him, but not by the local authority or social services department. And then the judge, it's not entirely clear in my submission what the judge's conclusion on Part 7 was. He makes some observations about it at paragraph 58, but doesn't appear to conclude that a housing duty was owed. And in my submission, that's right with the courts, the judge below, this court. The respondent is not in a position to conclude whether the main housing duty to provide accommodation is owed to my client, because no such application has been processed, has been progressed. In fact, and in the absence of the local authority being satisfied with those matters, which it has not expressed itself to be, that duty is not owed. Now, that brings me then to what is the interaction? What does Section 23 actually do? We deal with this in our skeleton at paragraph 31 and paragraphs 43 to 46. We also deal with it, or at least the history of it, in the supplementary note. But before I turn to those, I should deal, as I've been invited to do on a number of occasions, with the case of Adole, tab 11. I was always coming to it. Now, the facts of that case are apparent from the head note, so beginning on page 250. Bottom of that page, H11. The claimant was a tenant of a 2-bedroom flat on the 8th floor of a block owned by a housing association. He was admitted to hospital to be treated for kidney failure, and whilst in hospital became paralysed from the waist down. So whilst in accommodation, became disabled in a way that required an assessment of his needs under the Care Act. He was substantially bedbound, required 2 people with the aid of a hoist to lift him in and out of bed, needed assistance to dress, prepare meals, wash and use the lavatory. So precisely the mainstream, if I might put it that way, care services that my lords have been adverting to. And he'd applied for accommodation under the Housing Act, one sees that at H13, page 251, and been put in the second highest band of priority in the housing allocation scheme. And sometime later, the authority had undertaken a further assessment under the Care Act, this is at H15, confirming that he needed to move to meet his care needs. Now, quite what the content of that assessment was and whether it was said that the services being provided were effectively useless in the accommodation he was in is not clear and is not explored anywhere in this judgment. He issued a claim for judicial review, one sees that at H17, contending that the authority had failed to provide him with suitable accommodation under the Care Act 2014. And within a month of that claim being issued, the authority had offered him a new home on the basis that if it was accepted, it would be adapted before he moved in. And he did so just 2.5 months after the claim was issued. But the claim continued in order for him to seek a declaration that the authority had been in breach of its duties to him and to seek damages for breach of Article 8. So this was, by the time it came before, in fact, Mrs. Collins Rice, as she then was sitting as a deputy, now Mrs. Justice Collins Rice, it was essentially a claim for damages. Now, the analysis of the various duties begins at paragraph 34 of the judgment, which is on page 258. And as is said in that paragraph of the judgment, the chronology has been set out up to that point in some detail because of the need to answer carefully the question at the heart of this case, whether failures in the discharge of their legal duties by the council during the course of these events, or to put the question another way, what should the council have done differently? That in turn is highly fact specific. So that's the focus on the facts of the individual case and what the council should have done differently. It is notable in my submission that there is no reference in the judgment at all to the case law that I've shown your lordships on when accommodation can be provided under the Care Act. And, as I say, no express consideration of whether the services that were being provided to meet Mr. Ridolo's needs were effectively useless in the accommodation that he was occupying.
Well, they weren't useless, but as the judge put it, his predicament was indisputably grim.
Yes.
It's a terrible case. He needed a wheelchair and the doors were too narrow to use a wheelchair.
Yes.
But even so.
But even so, the judge made the decision that she did on the basis of, well, so she made the decision that she did on the basis of Section 23. The decision she in fact made was that the local authority had acted reasonably in the actions that it took to try and identify more suitable accommodation, and therefore there hadn't been a breach of Article 8. That's what this case actually decides. But because of the way the case had been put in the application for declaration, there is consideration of this issue about Section 23 of the Care Act. And again, it's not clear what the arguments were that were developed before the judge there, but she says at paragraph 45...
Sorry, if you want to know the arguments, it's at paragraph 43, the last 6 lines. Mr. Cragg leading counsel for Mr. Ridolo, which I mean, it might be thought mirror some of the arguments that you're making.
Well, the point that I made that it's not clear what arguments were advanced on what is required under the Housing Act. There's, it's not, I say, no submissions to that effect are recorded. My submission is not about expedition of a housing issue in the sense of getting him something that he, getting something that he would otherwise be able to be allocated under Part 6, which is what was in play here, or indeed speeding up the process that may be required to consider a claim under Part 7. My submissions are about whether or not Section 23 excludes consideration of providing accommodation in response to his identified needs, or as a way of meeting his identified needs. Now, what was said then at paragraph 45 of the judgment is that on the face of it, the council was already required under the Housing Act to rehouse Mr. Ridolo. So if the council was already required under the Housing Act to rehouse Mr. Ridolo, it had neither the duty nor any power to meet his care and support needs in that way. And she then went on at paragraph 46.
Do you say she was wrong at paragraph 45 in the same way that you say the judge in this case was wrong?
Well, actually what she says at paragraph 45 is conditional. She says if the council was already required under the Housing Act to rehouse Mr. Ridolo, it had neither the duty nor any power to meet his care and support needs in that way. And it may be, in fact, that is don't, as I say, one can only glean what one gleans from the judgment in Idolo rather than the granular detail, but it may be that this was a case because of the priority and the availability, so the priority afforded to Mr. Idolo and the availability of the particular property that he was eventually allocated, that there was a duty to allocate that property to him because that was what the allocation scheme required.
Well, what she says at 45 is that what it was required to do was to apply its housing priority scheme,
Yes.
and that's what it did. So it wasn't in breach of the Care Act, and that's her reasoning. Is she wrong about? I mean, is this case wrongly decided or rightly decided?
I don't need to say, I think, that it is wrongly decided because it relates to a person who already had accommodation. I do say that she's not wrong to say the only obvious way to determine what it was required to do under the Housing Act was to apply its housing priority scheme. In this case, it was required. It appears it was required because he was put in the urgent band and there was a property available to apply that scheme and give him that property. But what she goes on to say then at paragraph 46 is that counsel were unable to identify any judicial consideration of the effect of section 23. Perhaps surprising, since the question is likely to arise in any case in which an existing council tenant's housing needs fall to be reconsidered in the light of supervening illness or disability. And it was really in response to that observation that we put in the note on the predecessor legislation, because, as I have shown your lordships, there was, and if anything, more broadly framed exclusionary provision in the predecessor legislation in section 21.8. And there are, in fact, a series of cases in which that was considered, and in which it was concluded that nonetheless the primary duty on the particular facts of those cases lay with the Social Services Authority.
Can I just ask as a matter of, I couldn't work it out, a final answer. Was a buras referred to in this judgment? Although it is a law report, it doesn't unfortunately give us what cases were cited.
So, Idolo was decided on, Idolo was decided on the 8th of April 2020. A buras is a 2019 case handed down in October 2019. So,
it was in buras was mentioned in my scalison. I've just looked at that.
Right.
Thank you.
Good. Thank you. We'll accept that evidence.
that's helpful. That's not a question that I was able to answer.
No.
Sorry to ask.
No, I'm sorry, it took me a while to find it. But
Yes.
So cited but not referred to. And I'm sure my learned friend can give us more detail about what was and was not argued in Idolo, but the rest of us unfortunately have to work from what's actually reported on the face of the law report. So what's reported on the face of the law report is that an argument was made from General Care Act principles that rehousing can and should be pursued by social services to meet eligible needs. Apparently drawing support from the examples given in Section 8 of the Care Act, but not, as I say, referring to the case law on the narrow situations in which it will be appropriate to provide accommodation to meet Care Act needs. Now, what the judge decided, or the passage particularly relied upon by my learned friend in Idolo is, of course, the sideline passage, paragraphs 47 to 48. And first of all, she says it is clear that there is an intention in section 23 to give a measure of priority to the general scheme of the Housing Act over the specific scheme of the Care Act. Now, so far as that goes, I have no issue with that. As I've said, the purpose of Section 23 in my submission is to prevent the Housing Authority pushing off its responsibilities onto the Local Social Services Authority, relying on the fact that accommodation may be available in extreme cases to ensure that a disabled person isn't left destitute and without their their care and support needs being met. But that doesn't enable the local housing authority then to say, well, that's fine, we don't need to provide any accommodation. So where it does owe duties, those duties will supersede the Care Act duties. It will have to provide that accommodation, and there will be no need for the accommodation to be provided under the Care Act. Okay. But where it doesn't owe those duties, where it may not owe those duties or no such duty has been established, is the territory in which we find ourselves in this case. And so in my I do submit that the judge's conclusion in relation to Part 6 is wrong. To the extent, as I say in the skeleton argument, as we say in the skeleton argument, that it means that a person who is eligible in the sense of not excluded from assistance under the Housing Act because not subject to immigration control, potentially ends up street homeless in circumstances where a person who was subject to immigration control would be provided with accommodation, or may be provided with accommodation under the Care Act. I say that can't be the correct reading of this legislation, and that it wasn't an issue that arose in Adolo, because in Adolo, unsatisfactory, horrific as the circumstances in which the claimant was living in were, there was accommodation, there was a place in which the care and support could be provided. It wasn't rendered effectively useless because he had no home. And so I don't have to address the situation where a person has a home and is looking to move on grounds of their reasonable priority under the allocation scheme, because that is not this case. This is a case about someone whom the local authority considered at some time needed to be provided with accommodation by them in order that their care needs could be met, and otherwise they would have no home. That is the factual matrix with which we are concerned. Now, as I say, Adolo, after those paragraphs, largely goes on to consider the reasonableness of the process followed by the local housing authority in this case. But it does also refer at paragraphs 61 to 62. No, that's the wrong. Sorry. Paragraph 68 on the facing page 265. To this not being comparable to the case of Bernard and Enfield, with which the judge said there were some factual and circumstantial similarities. That was a case, said, in which the relevant housing department had placed a very disabled person and her family into entirely unsuitable accommodation, simply failed to act on the recommendation of the social services department for a move, failed to respond to correspondence and court deadlines, and failed even to admit that a continuing housing duty was owed until the case came to court. Now, we've put Bernard in the supplementary authorities bundle, it is not a housing case. It is show the court very quickly the cases that we've put in, but the point to make about that is that Bernard was not only not a housing case, it was a case in which an order was made by consent, and the local authority conceded the duty to provide accommodation under Section 21. An order was made by consent, and the person on the hook for not complying with that consent order was said to be the Director of Social Services. So very much not a housing case, but what I say about Idolo before going to the other cases is it is not directly analogous to this case. It does not concern a person who had no home, but a person who was looking for rehousing. In so far as the consequence of it would have to be that a person who is eligible under the Housing Act may be left street homeless in a situation where a person subject to immigration control would not be. So it must be wrongly decided, but I don't think need to go that far because I think it can be, my submission is that it can be distinguished on that basis. It's also a case that was, it appears, decided without a proper understanding of the Bernard case, which clearly was referred to, and the other cases that lead up to it. So,
but the discussion of Bernard and this part of Idolo is concerned with whether there's a Human Rights Act claim under Article 8.
yes.
That's not a question which arises
No,
in our
not
case
at
at all, is it?
No. So in a sense, I wanted to submit to you, I considered submitting to you that all of this was obiter, because actually what the judge was considering in Bernard was whether the delay in providing suitable accommodation under whatever duty was a breach of Article 8. And that's the main focus of the judgment, and effectively her decision is that the local authority did its best and acted as promptly as could be expected. As promptly as could be expected being 6 months from being put in the urgent bracket, but nonetheless, that's what happened. I don't think I can make that submission because on behalf of Mrs. Idolo, there was an application for a declaration that the local authority was in breach of its duties under the Care Act, and that was refused. So the judge did deal with those paragraphs in order to determine the outcome of the case. I assume my learned friend will confirm, having been there, that that's...
Yes. Can't really remember.
Yes, I was just with an eye on the time. I wonder if it might, that might be a good moment, a convenient moment to then come back to the other cases and the sweeping up points after lunch.
Well, what do we still need to look at from your point of view?
Well, I want to show you very briefly the cases that we put in yesterday, and so the approach of the courts under Section 21.8, because that is a mirroring provision, and in my submission that should assist you here.
I think what we'll undertake to do is have a look at your short supplementary skeleton and see whether we want to be taken through the supporting material. You've shown us the National Assistance Act 1948, that's very helpful. Whether any of the cases take the matter any further, I'm not sure. Is there any, subject to your consulting with Miss McGinn, is there anything else which, any other ground you feel you haven't covered?
No, my lord, after showing you those cases, it was really just pulling together round one and round two. So what I haven't shown you, and I can just give you the references, is the Care Act assessments and the needs that the client has, but those, of course, not subject of dispute.
No.
But something that the court in my submission does need to have in mind.
Well, I'm sure they're referred to in your skeleton argument.
They are, it's identifying lords, exactly where they are. So then just pulling together, by reference to everything that I've shown my lords, why I say ground 1 succeeds and why I say ground 2 succeeds. I don't imagine that would take me very much longer. So even with showing you the cases, I would imagine another half an hour.
I don't think you should count on having another
Subject
half an
to
hour.
judicial.
It is a one-day case, and of course, appellants tend to have to cover more ground than the respondents. But even so, we must give Mr. Swirsky some time. All right. Well, you have a word with Miss McGibbon, and let us know on what points you need to address us, and we'll return at 2 o'clock.
No, it's good. It's good. Thank you. It's very helpful.